Durkee, you wanted to say something?
Your Honor, my first husband never spoke to Mrs. Packard about my dad's funeral, which is, she only brought up his name because he's deceased. And then there's no way to have a witness say, nope, that never happened.
And your first husband, when, were you divorced or did he die?
Oh, no.
And what year was it?
My first husband died in 2011.
Okay.
My dad died in 2019.
So anything the first husband, it would be hearsay anyway, Ms. Packard. And here in the time, the court does have some discretion to admit hearsay, but if it was said in 2011, many things could have changed between 2011 and 2019. So I'm not going to hear anything else about the funeral.
You don't want to hear anything that has to do with proving anything that Wendy screwed up this whole time, Your Honor. You have been biased right from the start.
Okay.
I'd like to apologize.
Oh, quit sucking up, Wendy.
That's not how we were raised. It's not. She has untreated mental health issues.
Oh, Wendy,
Okay,
please,
we're not
so
going
do
to
you.
get into dissing each other's mental health or anything else.
Mine
here.
actually are managed, Wendy. You should try it.
Okay. Ms. Packard, if you keep interrupting, I'm going to have you muted and then just call on you when I want to hear from you. Do you understand that, Ms. Packard? Ms. Packard? All right. So now there is a concern about the bill submitted by Ms. Durkee for her time. And I have reviewed that bill, and I do think that there are some things that are rather high on that bill. And we can also talk about the billing rate. So Ms. Wendy Durkee, how did you come up with a billing rate of $45 an hour?
I was told that that's what the rate was, and that's what I charged for my seamstressing.
Okay, I've never heard of a fixed rate for doing the work unless you happen to have a special skill in doing that. So, Ms. McCann?
Yes, Your Honor. Ms. Durkee asked me, and I told her that I was seeing anything from 35 upwards of 75 for special circumstances. I also know people who are charging $3.50 an hour because they're lawyers. So I just felt that with all of the litigation, the fact she has to attend every hearing, trying to find his will, and the fact that she was not compensated for any of this, and it looked likely she wouldn't be compensated for any of this, that 45 was mid-range, and accountings are difficult to go through, and inventories were not easy in this case because it was, equipment. Equipment that had been sitting in fields. So it was a lot. Title searches, whether there were liens. This wasn't a standard hand out the china, sell the house kind of estate. So I agreed with her that I thought 45 was reasonable.
Okay, well, the court was going to allow a rate of $35 an hour for Ms. Durkee. And I certainly recognize that Ms. Packard has filed multiple repetitive pleadings in this case, which take time to review. And attorney meetings and hearings. We've had a lot of hearings. We've probably devoted more to this relatively small estate than I have had to devote time to, an estate of over $1 million. And that's in court time and Ms. McCann's time. However, I am going to cut the number of hours somewhat on those two categories, attorney meetings and hearings, and 2653. I did require Ms. Durkee to appear in person at an initial hearing, but if she wishes to appear by video WebEx, that's fine. Or
I don't have internet, Your Honor.
oh, you don't have
I
internet.
tried
That's, I
at
think,
the
why we ended up
library
with that.
and it didn't work.
Yeah, we're at some point switching to Zoom, which might work better from the library, but they initially told us that would be in July, and now we have no idea. And if you go onto the website where it says schedule for Zoom integration, it doesn't have anything listed. At least it didn't last week. I haven't checked it this week. I do think it will work better, and it will be easier for all parties to use it. But you're welcome to come in person, and when you're in person, I try to be in person as well, unless I'm not here for some reason. But, I haven't required your attorney to come up because that would be an additional expense to the estate of her transportation time. So we don't want to do that. So I'm going to redo the hours for reviewing opposing party pleadings. I'm going to reduce that to 20 hours. And the attorney meetings and hearings to 25 hours. Just recognizing that this is, ordinarily that would be way out of line, but this estate has been complicated. We also have to recognize that it was complicated, at least initially at the beginning, by the list of interested persons and your suggestion that the state police locate your sister.
Oh, they knew right where she was, but I will not ever have any contact with her, and that's part of the reason she's dragging this out, is because it compels me to have contact.
Objection, Your Honor.
I'm not interested. It's clear that the two of you dislike each other. Okay? That dislike of each other has increased the costs to the estate in quite an amount. So that's what we're dealing with. I'm going to allow, as I said, 25 hours for the attorney meetings, 20 hours for opposing party, and a fee of $35 an hour. I haven't recalculated what that would be, but that will be the allowed fee for Ms. Durkee. Of course, Ms. Durkee is not going to get paid until or unless the house sells. With respect to Mr. Scoville's fees, Ms. Packard, tell me why you think Mr. Scoville shouldn't be paid.
Because he had said he wasn't charging me, and he didn't even ask me to sign any kind of a fee agreement until 4 months into the hearing, after he started to talk to Miss McCann about having the estate pay him. And that is in Miss McCann's, that is in the paperwork Miss McCann submitted.
Okay. Usually, or I don't know if I can say usually, I will say quite often in a contested estate, it is common for the estate to pay the legal fees on both sides.
He had said he was doing it pro bono, Your Honor. As I said, he did not even ask me to sign a fee agreement for 4 months until after Miss McCann brought up having the estate pay him, and then he submitted a fee agreement to me and told me I had to pay it or he was going to quit.
All right. Ms. Packard, I think this estate would have gone a lot more smoothly if you had kept Mr. Scoville as an attorney. It probably would be closed by now.
Your Honor, with respect, Wendy Durkee had 6 years from the time she took guardianship of Roy Durkee till the 2 years after he died, and she was required to have inventory every year. If she had done her job as a guardian and as an administrator and had everything set up for the probate, and hadn't fought me on seeing the gun, hadn't fought me on getting somebody down there to view the property, which I set up both times, it would have been done already.
So I've heard you state that, and I'm going to look up the guardianship case, which I do not have in front of me. Let's see.
She took guardianship 2016, Your Honor.
Yeah, and I was not the judge in 2016, so let's start from that.
Every year she was required to submit an accounting of his estate. And she even stated at the last hearing that she never bothered to submit a final accounting to the court when he died, which is totally egregious. And I can't believe that nothing is being done to her for it.
Packard, I do not want you using words like egregious or anything like that. So I'm going to look at his voluntary guardianship in 2016. I just found the case online.
Involuntary, Your Honor.
It was a voluntary guardianship at that point. It was. I'm looking at it. The problem is it's an old case and it is not in our system.
Paperwork I have says it was involuntary, Your Honor.
Please stop interrupting me, Ms. Packard.
Well, it's kind of hard to see when you're done talking, Your Honor. I can't see you.
Well, that's not my fault that you don't have video.
Not mine either, Your Honor, with respect. I tried. I reloaded everything to try and get
We're
it.
going to mute you for now, Ms. Packard.
So we do have that file here.
We do have it here. Let's look at what is here on the online file. Okay, so it appears that Ms. Packard was a party in that case. That's what it says in 2016. An evaluation was ordered. The hearing in June of 2016, at which point Mr. Durkee apparently testified that he did not want Wendy to be appointed as his guardian. Evan Punderson, I'm not sure who he was representing, reported that an investigation by APS and neglect by Wendy was unsubstantiated. OPS wouldn't take the case. The appointment of guardian was done. It doesn't say to whom. License to sell filed by Ms. Durkee. The log skidder was given permission to sell in 2016. I don't know whether it was sold. Ms. Durkee was having trouble getting access to his bank account with Merchants Bank. order here says Wendy Ann shall file an inventory, and there will not be an annual accounting due since she doesn't technically have anything to do with his funds. That was in 2018. He failed to file a personal status report. And she appeared at a hearing on the failure. And I can't tell whether anything happened. It's noted on January 2, 1920, that Ms. Durkee had called to let the court know that her father had passed away. There was a request that she filed a closing report and a copy of the death certificate. I can't tell whether that was done. Let me just look over here. The will was filed in 1020. I can't tell, so we'll have to pull out that file. However, it looks like she was not in charge of his finances. I would need to look and see whether she actually sold the log skidder, which was, she was given permission to sell that to cover back taxes. Or I can ask Ms. Durkee. Ms. Durkee, did you sell the log skidder?
No, ma'am, it needed to have the piston put in and was not drivable and was on my dad's property. No one was willing to come and repair it with my dad there because he could be challenging. So my husband and I made up the difference between what my dad had.
So you paid the real estate taxes.
We paid about half. The redemption was $6,465.34. We paid around $3,900.
Right. We'll want to take a look at that file, but it looks like, it's interesting. It's filed as a voluntary, but I think it ended up being an involuntary guardianship. Looking at
Dad
the
decided he didn't need any help kind of partway through it, which was dementia. But
right, and I can't read the report by the evaluator here because it's not. It just says a report was received. It doesn't say what it said. So
it was conducted at UVM Med, if that helps you.
it says it was done by Cheryl Bellman and admitted into evidence. So I have to look in the physical file, which is here at the courthouse. But in any event, the court, just for Ms. Packard's awareness, the court relieved Wendy of any responsibility for filing annual accountings in the guardianship. So that is not something I can undo or, do anything about. So we're going to move on from that.
Your Honor?
Oh, yeah, Ms. McCann, thank you.
Thank you.
I was looking down at the objections.
Mr. Scoville filed his fees. Should he be allowed to file? I mean, he filed with the executor, the administrator, as a claimant or creditor. Should he be contacted to ask him to give a sworn statement about, when he engaged with the client by letter, what the fee structure was? If he's denied, then, he has the right to appeal. So I just like to make sure that all the facts are in front of the court.
Yes, I mean, I find it hard to believe that Mr. Scoville would have agreed to do this pro bono. Our esteemed bar counsel, Mike Kennedy, certainly suggests that getting a fee agreement in writing at the beginning of a case avoids litigation of the kind that we're talking about here. So I think obtaining a statement from Mr. Scoville regarding his fees would probably be a good idea.
All right, thank you, Your Honor, I'll write him a letter.
Thank you. Okay, so let's unmute Ms. Packard and hope that she can answer questions without interrupting.
She's muted.
Okay, Ms. Packard, I am looking at the document I think that you filed. Well, it's dated 7/14, okay? I'm trying to go through your document and make sure we have covered things. The Franzoni refund overpayment, they had to make an advance to him. Is that correct, Ms. McCann?
Yes,
And he refunded what wasn't used.
No, Your Honor,
Correct.
that was my mistake. I incorrectly read the invoice. So because Ms. McCann was his first client, he gave her a,
estimate,
not a rebate,
a discount?
yes, thank you, a discount. So I had looked at the raw figure before the discount and sent him the check for that. And then he refunded the difference between the discount that he had offered her and what his raw figure was.
Okay. And so Ms. McCann, did you keep that? Or
No,
did you give that back to Ms. Durkee?
I think it was sent back to Ms. Durkee and she put it in the estate account.
Because it came out of the estate account.
Correct.
Okay, Ms. Packard, do you understand that now? I think that was helpful to have that explanation.
Yes. Going back to Justin Scoville for a minute, I have the email and the bill from him dated, which shows he didn't send that to me for 4 months, and showing that it was his first bill. Or not his, well, his first bill and his
Might
first
have
time.
Filed that with the court, but already, if you haven't and you wish to file it, you can. Ms. McCann is going to reach out to him. Excuse me. She's going to reach out to him and get his letter regarding what the original agreement was. If the court feels like we need to have a short hearing with you and Mr. Scoville to discuss that, we will schedule that. But, you know, I'm trying to move this case along, and the court's calendar is packed. And I am taking a vacation of slightly over 2 weeks in August. So, you know, whatever we can do without holding hearings, I want to try to do it. So let's go back to your objection. I'm on the third page here. I think your pages are not numbered. Vermont Superior Court fees, those speak for themselves. There's a charge for everything, just about, for filing fee, for, filing a motion for license to sell, for filing documents in a case. There are lots of fees that are charged by the court. They are statutorily set. They're not randomly set by the court or by me. It's set by statute, and in order to file, you have to pay those fees. So, checks cashed after Roy's death. Are those from his bank account or from the guardianship account? I'm sorry.
His bank
from the,
account.
Okay, have you identified what 6 checks you're talking about, Ms. Packard?
Yes, Your Honor, I have. They amounted up to about $400. They were all even amounts. They were cashed up to, like I said, up to 6 months after he died. They were written and cashed. And according to Wendy and Paula, all of his bills had already been paid, and none of the ones like the taxes and stuff were the amounts that were those checks were written for.
Okay, the checks that were, if they were written before his death
No, Your Honor.
and cashed after, there's nothing. If they were written after his death, then I've got more concern. So tell me, were they written before his death?
My understanding, Your Honor, because I don't know why they would be cashed 6 months after his death when, as I said, there were no outstanding bills that were that amount.
May I offer some
Okay,
clarification?
Ms. Durkee.
So, as was pointed out in your review of the guardianship records, my father had control of his finances. I was not a signer on his account. After my dad died, I did tell some people, if my father has given you checks, you need to cash them within 6 months, because he's deceased now, he can't write you a new one. The only one I can clearly remember was for Addison County Transit. And they would take him to appointments when I couldn't. But I was not a signer on the account. My dad was the only signer on the account, and he had to have written those checks before he died.
Right. If the checks were written before he died and they weren't cashed until afterwards, it is not the responsibility of the administrator of the estate.
With respect, Your Honor, you only have evidence saying that she was not a signer up to 2018. He died 2 years later. She could have been a signer after 2018.
The court will review the physical file, Ms. Packard, but there is nothing in what I can see online to indicate that that was ever changed. So,
In your file, you have a statement from the National Bank of Middlebury that I could not receive any information on the account, even as administrator, because I was not a signer on the account.
I believe I received that, and so Ms. Durkee and Ms. Packard, just think about the time we are spending talking about something that is perhaps worth $400.
Well,
Think about that.
my issue, Your Honor, is that Miss McCann, at the time I brought it up before, said it was to go to bills, but it didn't. So that's what's got me wondering where the money went.
But it did
It
go to
doesn't matter if the checks were written prior to his death, Ms. Packard. They could have been written for gifts. They could have been written for bills. They could have been written, to buy lottery tickets. You do have to cash a check within 6 months,